Okay, we should get started. Today is the second day, good morning. Today's the second day of talking about the definition of hearsay. And as I've mentioned before, and to reassure you, today is going to be the hardest, I think, day of the semester in terms of trying to argue trying to understand some of the arguments for non-hearsay. But you shouldn't be alarmed because although it is true that we spend a good, I don't know, almost a third of the course on hearsay, most of it is on exceptions, and exceptions to the hearsay rule are quite easy to understand. So today will be difficult, but things will get easier. And that was part of my reason for not asking you to be on panel. Also part of the reason is I didn't get it together till yesterday, and then I realized yesterday at about 1 o'clock that it was Super Bowl Sunday, and that some of you might watch the Super Bowl. Although I'm proud to say I have never watched a Super Bowl game, at least not since I was in 5th grade, I think. Not that I don't like football, I just don't like pro football. Okay, so here's what we're doing. Now, Mueller and Kirkpatrick spend quite a lot of time talking about it, and did many of you get through the reading despite Super Bowl Sunday and the incredible difficulty of Mueller and Kirkpatrick's approach? Many of you? No one? Can you just, you don't want to admit you did do the reading, maybe. Well, it was very difficult, and I actually don't know that I agree with a lot of what Mueller and Kirkpatrick say. So I have my own approach. Just about anybody you talk to, any evidence professor will have their own approach, and there's a lot of disagreement about a lot of the issues that Mueller and Kirkpatrick discuss. As you'll notice, they spend a lot of time criticizing courts for saying things aren't hearsay when they really are. What it comes down to is that basically a lot of times the courts just think something is reliable and they're going to find a way to call it non-hearsay. And of course you want to be able to make those sorts of arguments even if they're ultimately specious, because a good specious argument is actually a more valuable argument. It shows how smart you are. I'm sure you've heard that about that DA in the McConnell-Adams case. There's the great Thin Blue Line, awesome documentary about false accusations. And the prosecutor is quoted in that case as saying, well, any prosecutor can convict a guilty man, but it takes a really good prosecutor to convict an innocent man. So similarly here, any lawyer can make a good hearsay argument, but it takes a really smart lawyer to make a specious but persuasive non-hearsay argument. So that's what you'll hopefully learn to do today. Okay. We're going to review before we get into the issue of non-hearsay, because many of you are probably still confused about what the basic definition of hearsay is. Okay? So remember, this is the definition that you've got to get into your head. You've got to memorize, if not now, definitely before the end of the semester, that hearsay is an out-of-court assertion offered to prove the truth of the matter asserted. Now, what we're going to do today is we're going to talk about that distinction between what something is offered to prove and what something asserts. And we're going to really push hard on that potential distinction, okay? But before we do that, we need to make sure we understand the basic definition. So if Deborah testifies that Al killed Bob, and it's offered to prove that Al killed Bob, is this hearsay? Is this hearsay? One major danger for students is they learn a little bit about hearsay, and they see hearsay everywhere. Well, if Deborah testifies that Al killed Bob, there's nothing facially wrong with that, okay? There's no obvious hearsay issue. Now, there might be a hidden hearsay issue. Remember hidden hearsay? Hidden hearsay would come about if you said, well, why does Deborah say that? How does Deborah know, right? How do you know? And that's the personal knowledge objection. How do you know? Do you know that Al killed Bob? Okay? It's not hearsay, but it might be indirect hearsay or hidden hearsay if Deborah doesn't have personal knowledge, right? And is basing her statement on someone else's statement. When you are essentially quoting someone else, that's when you have the hearsay issue. Okay, so the easy prototypical example that we've used over and over again last Wednesday is Wendy testifies, Deborah said, Al killed Bob, offered to prove that Al killed Bob. Okay? And this is clearly hearsay. All right. And the thing that I think was hard, and I realized part of the reason why people were getting things 90% correct last week is that about half of you, if not more, weren't even voting. Is that right? You were afraid to press your little clicker because you knew that that clicker was going directly to the registrar's office? Did you know that? And that your name was then appearing as incorrect or correct, and that at the end we won't even have an exam? No, that's not going to happen. You don't want to think that. You do want to use your clicker, and you want to use your best guess, because otherwise I have no idea if you know or don't know the answer, okay? So don't be afraid to use your little clicker. Okay. But that's what I think. So I think last week, when I suggested that a tape showing Al killed Bob was hearsay, I think a lot of you probably thought, yeah, that is hearsay, because that's an out-of-court, it's not an out-of-court statement. It's an out-of-court tape of Al actually killing Bob. It doesn't rely on anyone's statement. It's not hearsay, okay? So let's get that straight. And this one, remember this one? Hopefully this one was pretty easy. Wendy testifies, I told the police that Al killed Bob, offered to prove that Al killed Bob. Is this hearsay? Yes, because quoting yourself is hearsay. And some of you said, well, that's silly. Wendy could just say, and Al did kill Bob. And they were exactly right. She can do that. You can get around the hearsay problem. But if you hide behind your own words, it's a hearsay problem. Wendy testifies, I testified at the prelim that Al killed Bob, offered to prove that Al killed Bob. Is this hearsay? Yes, indeed. It's not an out-of-court statement. It doesn't fit our easy definition. But remember, it's a statement other than one made at the proceeding. And since it's a different proceeding, quoting yourself from a different proceeding is hearsay. And some of you say, well, wait a minute, I've worked on cases. Last summer, I worked on a case, and we introduced all sorts of testimony from prior hearings. Well, it wasn't because it wasn't hearsay that you introduced it. It was because there was a hearsay exception. So another thing that causes a lot of problems for students is when you learn the definition of hearsay, you get confused because you're thinking of hearsay exceptions. Like someone came up to me over break, and they said, wait a minute, you mean we can't introduce police reports? You can't if there's not a hearsay exception, because it's definitely hearsay. Okay. So that's what we've done. Here's what we'll do today. Like I said, we're going to really push hard on this distinction between what something is offered to prove and what it is asserted. And I'm going to remind you that the attorney offering the evidence is the one who offers to prove something, and that it is the out-of-court declarant who asserts something. And in order to decide what is asserted, we have to make some inferences about what the declarant was thinking, what the declarant was trying to do. It's easy to know what the attorney is trying to do because you just ask them. You say, what are you offering this to prove? All right? We're going to consider illegitimate claims that you are not offering to prove the truth of the matter asserted. And these are claims that I started to teach because they start showing up on exams, where students, being clever, would say, oh, this is not offered to prove the truth of the matter asserted because what the declarant said is not identical to what I'm trying to prove. And if it's not identical, then it's non-hearsay. And you'll see that that is usually a bad argument. Okay? And we'll see why that's a bad argument. But then, after we consider the illegitimate claims, that what we are offering to prove is different than what is asserted, we're going to look at legitimate claims. And these are legitimate types of non-hearsay, statements that are not offered to prove the truth of the matter asserted. Okay? And I'll just list these now and say a little bit about them, but hopefully by the end of today's lecture, you'll have a better understanding of what they are. First, we'll talk about impeachment by prior statements. Okay? Notice that this is quoting someone on the stand, something they said previously. Well, that's hearsay. But it's not going to be offered to prove the truth of what they previously said. It's going to be offered to prove that they're an inconsistent person, and that will be non-hearsay, to prove inconsistencies. We'll talk about something called effect on the listener. Oftentimes, you want to prove a statement, not to prove the truth of the statement, but to prove that the statement was made, and that because the declarant made the statement, someone else who heard the statement thought or believed something, or reacted in some way. An effect on the listener will be non-hearsay. And classic examples of effect on the listener are things like promises or threats or warnings. That's something I'm thinking about starting to teach. Did any of you do any like philosophy of language as undergrads? Did you ever read Austin, Things We Do with Words? Anybody? I'm not going to quiz you on it if you say yes. So, anybody? Surely, yeah. If you go back to that, actually, Austin explains what non-hearsay is when we talk about words that do things. That's going to be a key to thinking about non-hearsay. An effect on the listener, threats, promises. Do you remember when Austin talks about those are all performative statements? No? Well, you'll kind of remember as we go through it today. Verbal acts. Verbal acts are really a species of effect on the listener, but they're a species that has legal significance. So, for example, an oral contract, right? If you mow the lawn, I'll give you $6. That's hearsay. So how would you ever prove an oral contract in court? You'd say, he said he'd give me $6. Sorry, he said it. It's out of court, right? Doesn't make any sense. Turns out that's going to be a verbal act. Words that have legal significance are going to be considered non-hearsay. We'll talk about verbal objects. Very different than verbal acts. Don't be deceived by the fact that they both have the word verbal in them. Verbal objects are really just a means of identification where words form part of the identification, and you can be misled. You see the words and you see a hearsay problem. But verbal objects avoids the hearsay problem because they don't use the words for their assertive content. They use the words for the fact that they are a certain pattern and that that certain pattern matches something, say, in the defendant's possession. It's very abstract, but the examples will be quite clear. Knowledge. You can prove someone's knowledge. So you're not trying to prove the truth of what they say, but you're proving that they know of something that everyone acknowledges is true, and that's considered non-hearsay. That's especially difficult conceptually. Performative statements. Performative statements are when you mix together words and non-assertive conduct. Okay? Well, let me stop right there. Is non-assertive conduct hearsay? Head nods? No. So if you mix words with non-assertive conduct, what do? Well, courts will allow it because they'll say that it's more than merely words. And because it's more than merely words, it doesn't have the hearsay dangers. And the last thing we'll talk about is lying. Can you prove that someone said something not to prove the truth of what they said, but to prove that they said something untrue? And this is one of these interesting examples where the courts will universally treat it as non-hearsay because it doesn't fit the facial definition of hearsay, right? You're not offering it to prove the truth of the matter asserted because the person offering it to prove doesn't think it's true, right? Clearly non-hearsay. What the courts overlook, however, is the rationale for the hearsay rule. The rationale for the hearsay rule would suggest that proving lying is a hearsay problem and could and perhaps should be treated as hearsay. So if you can understand, if you get to the end of the today and you understand the argument for why lying is and is not hearsay, then you've got 100%, and you'll be doing great. Okay? Okay, so remember, we're going to push hard on that first point. We're going to push hard on the distinction between what something is offered to prove, which is the attorney offering the evidence, and what is asserted, which is the declarant. Okay. So remember, offered to prove, you need to remember who is offering the evidence. And the truth of the matter asserted, you need to remember who is asserting, right? Who is asserting? And the answer is that offered to prove refers to what the party offering the evidence intends. And the judge can ask the attorney, what are you trying to prove? And remember that any time you consider any piece of evidence, the first thing you ask is, what are you trying to prove? Because your relevance assessment will depend on that question. And it turns out your hearsay assessment will also depend on that question. So why are you offering to prove that Deborah said Al killed Bob? We think it proves that Al killed Bob. Thank you very much. Okay? And the truth of the matter asserted refers to what the declarant intended. Excuse me. What the declarant intended. And when I use the word declarant, I mean the out-of-court declarant. I mean the hearsay declarant. Okay? So if Wendy testified that Deborah said Al killed Bob, do we care at all what Wendy intends through her testimony? Do we care at all for hearsay? I won't ask you to pick up your clickers if you give me some head nods. Do we care at all what the witness intends? Is it what the witness intends? No, it's what the declarant intends. So make sure you don't get that mixed up. It's what the declarant intends. Okay. Well, let's go back to our classic example, and then I'm going to show you some cases where you might think you have a non-hearsay argument because there's not a facial similarity between what is offered to prove and what is asserted, but it still is going to be hearsay. Okay? And excuse me, I'll do this without offending anyone. Oh, I forgot to turn off the microphone. Sorry about that. Ah, man. Okay. Now, if I fall down in class, you'll probably just leave, right? But could someone call 911? All right? It's okay to leave, but just, all right. Offer to prove equals matter asserted. Wendy testifies, Deborah said Al came into the bank with a gun. Ooh, a little different. A little different. Well, it's different, but let's say the attorney offering it says, this is why I'm offering it, to prove exactly what Deborah said. Is that hearsay? Yeah, that's clear. Offered to prove the truth of the matter asserted. Okay. Now, the attorney he's a smart one. Attorney says, no, that's not what I'm offering to prove. What I want to prove is I want to prove that Al robbed the bank. And Your Honor, this is not offered to prove the truth of the matter asserted. Not the same, not hearsay. Is that a good argument? Strongly agree, strongly disagree. No, it's a terrible argument. You are still trying to prove that Al came in the bank with a gun, right? You are trying to prove the truth of the matter asserted. You're trying to prove more than that. You're trying to prove the truth of the matter asserted, plus the additional inference that what he did with the gun was rob the bank. So, as long as what you were trying to prove includes the truth of the matter, as long as what you were trying to prove includes the truth of the matter asserted, then you have hearsay. All right? So don't get deceived by facial dissimilarities between offered to prove and truth of the matter asserted. Major error. Students make it all the time. You won't. Okay? Seems pretty simple. Well, is this true? Does the matter asserted identical to what the declarant said? It was last time, right? Those two previous examples it was. Came into bank with a gun. She meant to say came into bank with a gun. Well, sometimes, though, people do something called implying things. Wendy testifies that Deborah said, they ought to put Al in jail. And it's offered to prove that Al robbed the bank. If you say that what Deborah is intending to assert is that they ought to put Al in jail, and that's all she's intending to assert, you can say, look, that's different. And notice this is different than our previous example. Right? This is different than our previous example. Here you might say the attorney is offering to prove less than what Deborah said. So is this hearsay? Facially, it's not the truth of the matter asserted. But conceptually, it's going to be a hearsay problem. So let's work that out. Let's consider the argument that it is not hearsay. You'll say this. You say, look, the assertion Al ought to go to jail, which is the intended assertion, what Deborah said, is not the same as what we're offering it to prove. Al robbed the bank. What would be an argument that you are offering to prove the truth of the matter asserted? Well, remember, you often assert more than you say. You often imply. You often can read between the lines of what someone says to what they're trying to express. And remember what an assertion is? An assertion is when you're trying to express something. It was him. I'm saying it and pointing, but I could just go. But notice that I'm intending to say more than just extending my finger. I'm intending to say something. So when Deborah said Al ought to go to jail, she intended to communicate, or she intended to express the fact that Al robbed the bank. And when assessing hearsay, you not only consider what the declarant literally said, but also what the declarant intended to assert, or intended to express, or intended to communicate. So the correct answer is, this is hearsay, and you look beyond the literal statement to what the person intended to communicate. Okay. And then the easy way to remember this is this rule. The matter asserted includes what the declarant implied. Now, do you remember learning about the difference between implied and infer? Does anyone remember that? This would take you a little bit further back, probably not in college. I think it was in high school that they usually teach that. And yet people mix up those words all the time, and actually mixing up those words will confuse you when it comes to hearsay. Implied is what the speaker is trying to do. Inferred is what the listener can do. You want to think about what the speaker was trying to do in deciding whether something is part of the matter asserted, okay? What the declarant implied. And actually, I'm sure you don't remember this, but since I've seen this clip 100 times, Berger commits this error in his cross-examination in one of the first clips we saw. He said, was he inferring that the horse was doped? And he should have said, was he implying? So don't feel bad if you make a mistake. Even Warren Berger, no, it wasn't Warren Berger. Even Prosecutor Berger has made this mistake. Okay, any questions about this? Good. So that's the end of the misconceptions. Now we're going to talk about, and this is the hardest part, now we're going to talk about legitimate arguments that you are not offering to prove the truth of the matter asserted. Okay? And you're always going to analyze what the attorney is trying to prove, and you're going to compare it to what the declarant is trying to express. And you'll consider not only the literal words that we always assume the declarant is trying to express, right? We always assume you mean what you say, but also what the declarant is trying to imply, what the declarant is implying. And I'm going to give you a rule that you can use that I think pretty well separates out the good examples of non-hearsay and the bad examples of non-hearsay. And this rule will feel a little unnatural, okay? Unnatural because it doesn't exactly get at all the hearsay dangers. Remember that the hearsay dangers are perception, memory, narration, and sincerity. And so anytime you make a hearsay objection, you can say to the judge, we need to get Deborah in here because she may have misperceived, she may misremembered, she may not have meant what she said, and she may be lying. But remember also, we talked last week about how the hearsay rules, for some strange reason, don't care so much about those first three infirmities. The hearsay rules care about sincerity, okay? And let me remind you of that. When we talked about non-assertive conduct, we said the dangers of perception, memory, and narration are still severe, right? How so? Well, a classic case of non-assertive conduct is the truck driver in front of me pulled into the intersection, offered to prove that the light was green. That would be non-hearsay. But are there dangers in assuming something about the truck driver's mental state? Yes, we assume that he could see whether the light was red or green, right? We assume that he could remember whether the light was green or red when he pulled out into the intersection. We assume that we're properly reading his actions. Maybe he was turning right on red. All of those problems, perception, memory, and what you'd call an analogy to narration, are at issue in non-assertive conduct. Well, what isn't at issue with non-assertive conduct? Why don't we treat it as hearsay? We don't treat it as hearsay because it's not insincere. If you're not trying to say something, you can't be lying, right? Lying is something you intentionally do. And so if there's no danger of insincerity, it's not hearsay. Now, why would they care so much about sincerity? This is actually of some historical interest, which of course means it's boring. But it's important because you will understand hearsay better if you understand the historical reason. You know what they cared about when they first started thinking about hearsay? They didn't care about cross-examination. This was the 18th century. Back in the 18th century, the prisoner would stand up, and the prisoner didn't even have a lawyer, and the prisoner wouldn't question anybody, right? Sometimes he might interject a question. I didn't really do that, did I? And that's about it. What they cared about in not admitting hearsay was what they thought guaranteed truth. What they thought guaranteed truth back then, before we had cross-examination and lawyers, is they thought the oath was what guaranteed truth. So the problem with hearsay is that it was unsworn. Well, how would the oath matter, right? The oath would matter because the oath guarantees that you're sincere. When you take an oath, does it eliminate problems of perception, memory, and narration? No, but it does eliminate the problem of sincerity, assuming the oath is effective, right? So the reason why sincerity is the central ingredient in hearsay versus non-hearsay is because historically, that was the one thing that they really thought the trial process could solve. So when you make a hearsay objection now, you tell the judge as a rationale, we can't test anything. We can't test the perceptions, memory, narration, or sincerity of the speaker. And the judge may well grant your hearsay objection. But if you're technically arguing whether you're offering something to prove the truth of the matter asserted, notice that you're dependent on what the declarant is intending to say. You're dependent on the declarant's voluntary decision whether to tell the truth or not. And that's what technically will distinguish hearsay from non-hearsay. Okay? So hopefully that will make some sense of this weird test that I'm going to give you that will help you distinguish between hearsay and non-hearsay. This is the test. Whenever I give you a sentence that the declarant says and ask you, could you argue that this is non-hearsay, assume that the declarant is secretly insincere. Assume that the declarant, without making it obvious, is trying to deceive. So you could only discover that, right? How would you discover secret insincerity? You don't look at their face, because they're very good at secretly being insincere. You'd have to bring them in, put them under oath, and question them, right? You'd have to use all those trial tools to discover that insincerity. If, however, you make this assumption, you say, yeah, they might be secretly insincere, but you know what? It still matters that they made the statement. It still matters. It still makes a difference. It still proves something. If that's true, if the statement still has some probative value, then you can argue that this is non-hearsay, right? Now, I say it this way. I say, if so, the statement probably has a non-hearsay purpose. But you can argue, you can say to the judge, we're not offering it to prove the truth of the matter asserted. We're offering it to prove effect on the listener, that it's a verbal act, right? One of these other non-hearsays, okay? So think about that for a second, and then we'll start with our first example of what is universally considered to be non-hearsay. Okay. Impeachment by prior statements. So remember Deborah, right? And Deborah has told Wendy that Al killed Bob. Okay, have that in the back of your head. Well, guess what happens? They bring Deborah to trial. And Deborah comes into trial and she testifies, I saw Carl kill Bob. Uh-oh. What do you call this? You know what prosecutors call this? Well, disaster. They say she flipped. They're always confident that Al must have gotten to her, right? Some kind of threat. Drove by her house, honked the horn. Hi, it's Al. How you doing, Deborah? At any rate, the prosecutor doesn't give up easily, right? And if you live in California, oh, you do. And if you practice in California, well, you probably will, and you practice in California State Court, there's a good chance of that, then you will actually be able to prove up your case through that prior inconsistent statement because of California's prior inconsistent statement hearsay exception. But you don't know any of that. For now, you're the prosecutor, and you just want to prove that she's a liar. So you present your good old witness, Wendy. Wendy gets up on the stand, and she testifies that Deborah said Al killed Bob. And the judge says, what are you trying to do? And the prosecutor says, I'm trying to prove that Al killed Bob. Is that hearsay? Offer to prove the truth of the matter asserted. Yes. What if the prosecutor says something else? The prosecutor says, no, Your Honor, I'm not offering to prove the truth of the matter asserted. I'm offering this evidence to impeach Deborah. Now, you've heard that word, impeachment. But now we want to take it apart, right? Well, what does he mean when he says, I want to impeach Deborah? The answer is classic impeachment, when you simply offer a statement to prove not that what someone said at some prior time was necessarily true. If you say, I don't know when she's telling the truth, but I just want to offer this evidence so that the jury knows how inconsistent this person is, then it's not hearsay. Prior statements offered to impeach, what they mean by impeachment is they mean that Deborah says inconsistent things. And that because she says inconsistent things, particularly inconsistent things about the central issue in this case, she cannot be trusted. So if you're offering the evidence only to impeach, are you then offering Deborah's statements to prove that Al killed Bob? No. What do you think the jury should do to Deborah's statements? She should disregard everything Deborah has said. Because we don't know what's true, right? We don't know what's true. Now, this distinction between offering something to impeach and offering to prove the truth of the matter asserted, in this context, is often called the distinction between impeachment, right, and substantive evidence. And all that means is that impeachment is not offered to prove the truth of the matter asserted. It's just offered to prove that the declarant is inconsistent and will hopefully result in the jury throwing out both statements. Substantive evidence is when you offer a prior statement not merely to impeach her trial testimony, but to suggest to the jury that what the person originally said was true. Right? But notice that if you want to get to this point, if you want to get to the point that what Deborah originally said was true, gotcha, just a sec. If you want to get to the argument that what Deborah originally said was true, notice that you're assuming that Deborah was sincere when she said Al killed Bob. Impeachment doesn't make that assumption. For impeachment, you can assume that secretly, deep in her heart, she didn't really believe Al killed Bob. But when you prove that someone is inconsistent, what you say is, we have no idea when this person is lying or telling the truth, right? If she's secretly lying about these kinds of things, these serious kinds of things, that seriously impairs her credibility, and we should not trust her, right? So impeachment doesn't make any assumptions about Deborah's sincerity when she made that original statement. When she made this statement. Substantive evidence does, and so in order to introduce a prior inconsistent statement as substantive evidence, you have a hearsay issue, And the only way you're going to do it is if you have a hearsay exception. Yeah, you had a question? Uh-huh. With the trial testimony. Well, they're consistent in that both of these things happened, but they're inconsistent to the extent that when she says Carl killed Bob, she's denying that Al killed Bob. Yeah. Oh, these both really happened. You're just saying Wendy really heard this, but the issue is whether this was true. This assertion can't be true. That's what's inconsistent. Okay. Any other questions? All right. Let's see. This makes sense. This makes sense. Take out your clickers. This is actually kind of interesting for me. Impeachment versus offer to prove the truth of the matter asserted. Now, everybody can vote on this, right? Because it's not quiz. Just does it make sense? Because I want to know kind of the sense whether you think you could explain it back to me. I'm a little nervous. You guys are slow. The clicker guy told me he had a class of 400, and they were so fast at their clickers, it was like 30 seconds, and they had 400 votes. And you know, it's not like you don't have to press it like you're pointing it at the remote. That's not everybody. Come on. Uh-oh. What happened? Oh, not too bad. So about 15% are really confused. Any questions? Any more questions? You're just saying, I can't get it from this guy. I'm going to go read something else. Yeah. Abe. Yeah. Yeah. You tell the judge you're only offering it for impeachment. Yeah. If the judge thinks, what will the judge do? Let's say the judge thinks the jury isn't going to be able to use it just for impeachment. What does it now become a problem of? Yeah. Right? Because now the jury is using it for a wrong purpose, misleading the jury. So the judge can exclude it if you say, oh, I'm only offering it for impeachment. But technically, assuming the jury does its job, it's clearly different, right? Because if the jury throws it out, the jury will basically say, we haven't heard anything. Deborah doesn't make one iota of a difference in this case. And I'll talk more about this when we get to the hearsay exception for inconsistent statements. What would happen if the prosecutor rested at this point and it was really just offered for impeachment? What would happen if the prosecutor says, I'm only offered for impeachment and I rest my case? And this was all that had been presented. Judge would direct a verdict for the defense, right? Because there's been no evidence that Al killed Bob. That's one way you can tell if they're offering it for substantive evidence or just as impeachment, right? But if it was offered as substantive evidence, and you'll see you can sometimes offer it that way under a hearsay exception for prior inconsistent statements, then the prosecutor could rest, and the jury could conclude that Al killed Bob, because they could make the decision that this was when Deborah was telling the truth, okay? Any other questions? Yeah. Impeachment is non-hearsay. As soon as you say, I'm offering this under the inconsistent statement exception, you're acknowledging it's offered for a hearsay purpose, but you have an exception, okay? So non-hearsay. And actually, maybe I should talk less about exceptions today so that you don't get confused. Everything I'm going to say today is about non-hearsay. Okay. Anything else? Yeah, Joel. Yeah, yeah. That's what I'm saying. Right, that's what I'm saying. So sincerity doesn't matter, right? So, because what I said to you is I said, assume she's secretly insincere. Maybe she's just joking. Well, does that still make us doubt Deborah? Yeah, because this is a woman who jokes and secretly jokes. She doesn't make it known that she's joking. We can trust that kind of person? Hell no, right? That's a credibility argument. So yeah, the idea is that if regardless of the sincerity of this person, we think it's relevant that they made this statement, that's a non-hearsay purpose, okay? So to talk about that on the slide, if you assume that Deborah was secretly insincere, when she made that out-of-court statement, this assumption we're going to make is about that hearsay statement. And I'd say, is the statement still relevant? Does it still matter that Deborah, however insincere, said, I'll kill Bob, right? That's still relevant because the prosecutor is saying, look, this is a woman who says inconsistent things at different times. And that undermines her credibility. Okay, that undermines her credibility. Now, I'll tell you something, and then I'll get to you. The advisory committee said, you know what? You can test her sincerity. She's on the stand. And so they created a hearsay exception for prior inconsistent statements that allowed all of these things into evidence, right? And that's probably what you're thinking, is you're saying, well, wait a minute. If she was secretly insincere, okay, but you can test that now that she's up on the stand, right? Testifying. Remember, Deborah testifies in this hypothetical. You have to testify for a prior inconsistent statement to be introduced, even as impeachment. But that argument did not win. That argument did not win. Yeah. Uh-huh. He'd say, I'm offering it for its truth. And then the judge would say, well, it's clearly hearsay. And then the prosecutor would say, okay, let's look at what the exception requires. And now they would move to the exception for prior inconsistent statements. And there actually are a lot of additional requirements that would have to be met for that exception to apply. Okay, okay, let's, any other questions? Let's go to effect on the listener. All right. Plaintiff sues drug company for damage to his kidneys when he took a drug. I'm going to give you a hypothetical and then explain effect on the listener. So get the hypothetical. Plaintiff sues drug company for damage to his kidneys when he took the drug. And the drug company says, hey, sorry, we're not responsible because we told you. I'm sure you guys, whenever you take drugs, since you're going to be lawyers, you probably read the product package insert, right? That long thing. Do you guys read it? Yeah, I always do. Put on my reading glasses. I've got a severe headache, right? But still I'm going to read the insert to make sure what the side effects are. And of course, as soon as you read the side effects, you start feeling them. But anyway, drug company says, sorry, we told you, we told you. And the drug company offers this out-of-court statement. And they say, this is not hearsay. This is offered to prove that the plaintiff had notice that there might be a danger. Classic case of non-hearsay. Classic case of non-hearsay. And, you know, you might ask yourself, when a drug company fighting a claim that a drug causes kidney failure, why in God's name would they offer evidence that their patient package insert says that it causes kidney failure? Why would they offer something that proves the plaintiff's case? They're not offering it to prove that the drug causes kidney failure. They're not offering it to prove. They're going to deny it. They're going to say, no, the evidence really isn't that good. But our patient package insert said it because we wanted to alert people that it might happen, right? So it's not offered to prove the truth of the matter asserted. It's offered to prove we said it, he heard it, and that's what effect in the listener is all about. Effect in the listener is when you offer a statement, not to prove the truth of the matter asserted, right? Not to prove that the out-of-court declarant, and here, who's the out-of-court declarant? The person who wrote the patient package insert, right? You're offering it to prove that the statement was made. Okay. And the way you can think about this using our secretly insincere, assume that the label writer was secretly insincere. He didn't really believe the evidence, but he talked to his bosses and they said, you know what we should do? Just to err on the side of caution, let's say it might cause it. Just like, you know, now they tell people that if you give your adolescent child antidepressants, they might kill themselves. Do you think the drug companies really think that antidepressants increase the risk of suicide? Depends on how evil you think they are. I think they probably don't. I think they probably think it's silly. But they say, but let's just put it in the warning so that we protect ourselves against liability, right? And notice that even if you assume that, even if you assume that the drug company didn't really believe it, as long as it's a secret, as long as they don't say in the paper package insert, some people say this causes kidney damage, but don't worry about it, right? As long as they don't say that, as long as they say it might cause kidney damage, that is notice to the plaintiff, that is legally significant, and it's not hearsay, okay? So effect on the listener, okay? I actually think effect on the listener is easy to understand starting with the example. And so I'll give you more examples. These are other examples of effect on the listener. The plaintiff testifies that the defendant said that the plaintiff is a lawyer, excuse me, slip, is a liar and a thief. Well, you probably don't remember this, but that was in the Watergate hearings, the Nixon, not Nixon impeachment, but pre-impeachment. And it was a senator from Hawaii who at the end of the Attorney General's testimony was heard, he didn't know the mic was hot, was on. He said, what a liar, after John Mitchell's testimony. And when they asked him afterwards, they said, you said, what a liar, we heard you. He said, no, I was saying, what a lawyer. So anyway, easy slip. Plaintiff testifies, defendant said, plaintiff is a liar and a thief. And it's offered to prove that the defendant defamed the plaintiff. Now imagine you go into a slander case and you try to prove the defendant's words, and the defendant says, objection, hearsay, and the judge says, sustained. Imagine how silly that would be, right? And you'd say, well, of course I can offer the defendant's statements. That's what slander is. And the judge would say, no, that's hearsay. And then you'd say, well, wait a minute. I'm not offering the statement to prove the truth of the matter asserted. The whole point of slander is that I'm offering a statement that I believe is untrue, right? So this is an easy case, because by the facial definition of hearsay, you can say you're not offering it to prove the truth of the matter asserted. And in fact, with the drug company example, you can say the drug company doesn't believe it causes kidney failure, so they're not offering to prove the truth of the matter asserted. And by that facial argument, you can see the distinction. But notice that the reason you are offering to prove it is because when someone says things that are false and demeaning, it hurts your reputation. It has an effect on the people who hear the statement, right? That's what you're offering to prove. You're offering to prove effect on the listener, not the truth of the matter asserted. Now, the next example is a little tougher. The next example is an example that oftentimes is offered to prove the truth of the matter asserted, and is a way to sneak around the hearsay rule, but that can be offered to prove effect on the listener. And the tricky thing here is that the listener, in this case, is the witness. The listener can be anybody who hears the statement. Okay? but here it's the witness. So the defendant says, the detective testifies, I was told that B had committed the crime. And remember, we talked about this on Wednesday, and we said, well, this is hearsay if offered to prove that B did commit the crime, right? Clearly hearsay. Offered to prove the truth of the matter asserted. But why might the detective nevertheless get to testify about what he was told? Well, let's say you need to prove reasonable suspicion. You need to prove the basis for a search warrant being issued, or the basis for a search on the scene, a stop and frisk. Effect on the listener. Maybe the person who told the detective was secretly insincere, but the detective had no way of knowing that. The person was secretly insincere. So the detective reasonably believed, hearing this information, that he ought to go after B. And all he's trying to prove to the jury is that reasonable belief, right? The effect on the listener. It's not hearsay. Another way of saying this is, as long as we're interested in the reasonableness of the detective's actions and not the accuracy of his belief, then we have non-hearsay. Okay? And the way to think about this in terms of the importance of sincerity is to say this, is to say that sincerity isn't assumed because the fact that the listener heard the statement gives it its probative value. Okay? The fact that this listener heard the statement. Another example, and this is actually a student thought of last year, and I hope it wasn't a personal experience, a statutory rape case in which the defendant wants to testify that the plaintiff said she was over 18. Can the defendant offer in evidence the fact the plaintiff said she was over 18? We know she wasn't over 18. That's why we're in court. Is it offered to prove the truth of the matter asserted? No, it's offered to prove that the defendant reasonably believed she was over 18. Now, if she was obviously insincere, you would not allow it. Because you cannot reasonably sleep with somebody when they obviously are lying when they say to you, I'm over 18. Sorry. But if you assume she was secretly insincere, then it is reasonable for the defendant to argue. Now, of course, you add into the mix, well, could he reasonably believe this given other circumstances? You know, the fact that she was wearing a junior high pep club outfit. Whatever. I should have asked that student more questions so I could give you more facts. But that case is over. Okay? So, yeah, Kate. Right. So let's say you were in a state where you had strict liability for statutory rape. Right. He wouldn't be able to introduce any of that. Yeah, Alma.
With the slander, I got a little confused. I mean, you were saying that, defendant said, I'm a horrible person, and you're trying to prove it's slander. And how I'm having a little trouble, like, when you said, like, it had an effect on my reputation, or could possibly have an effect on my reputation. That's why we allowed it in?
Yeah, effect on the listener. So, I mean, think about it. For slander, you have to prove that the person made a slanderous statement. So it's a necessary part of your case, right? So clearly it's probative. Okay, okay. Yeah, I know. These are the kinds of things that you need to go home and think about sometimes. Yeah, Joel. Uh-huh. Oh, yeah, it would be the defendant. Remember, the plaintiff is offering the defendant's statement that he's a liar and a thief. In order to prove the truth, that would be the defendant's job, and that would take other evidence. Yeah. Anything else about effect on the listener?
In the second case, the detective
Mm-hmm.
Isn't it a problem that, you know, if you have a detective saying, I was told that they committed the crime, couldn't the jury can say, well, you know, this upstanding police officer says he committed the crime, so
Right,
that's
right. That's just like, who was it? Joel. Did you raise that point before? Or a man up here. Yeah, it was Abe. So Abe, what would the answer be then? What would a lawyer who says, look, they're going to rely on the detective because he's an upstanding police officer, so prejudice. So you'd say the jury will not be able to use it just for the non-hearsay purpose. They'll use it to prove the truth of the matter asserted, and that would be a prejudicial argument then. It would be prejudice. Good. Anything else? Yeah.
So I guess off that though, does the judge give a limiting instruction, and then if so, the jury, I guess, convicts, but there's really no substantive evidence that the defendant should be convicted. How does the judge, I guess, direct the J and OB if maybe can't figure out what the jury is doing?
Oh, right. Well, if there's other evidence, then the judge wouldn't direct a verdict. And the judge, in giving a limiting instruction, has to assume that the jury obeys the instruction. And it's one of these fictions that courts will do that. Courts will assume that juries will follow the instructions. So if you're defending against that statement getting introduced, you're pretty upset, right? Because you know the jury's going to misuse it, and you fight hard to keep it out. But once it's in, you know, and if there's other evidence, jury's going to be able to use it however they want once they get to the jury room. Okay? So that's why when you make the prejudice argument, you know, you make the argument that way. You say the jury is not going to be able to ignore the fact that this is a detective saying that he committed this crime, right? And if the judge, you know, if the judge is more sort of pro-defense, then the judge will recognize the inefficacy of limiting instructions. There's not much else you can do. Anything else? Okay, why don't we take our break? It's 11:40, and come back at, oh, actually it's 11:37. This clock is fast. So come back in about 10 minutes, but I will start at 11:47, so don't stray too far.
How does the back and forth go on
Okay. Is it working? Sorry, yeah. The cough comes through loud and clear. Okay, so we're just finishing up with effect on the listener, and we're going to move to verbal acts. And just to give you an introduction to verbal acts, is verbal acts are really effect on the listener, but the reason why some courts will call them verbal acts is, well, one way to think about it is it's when words do things. That's why I mentioned Austin and performative statements, but that may not help you to understand. They're effects on the listener, and there are certain types of statements that have clear legal significance, right? And so I'm sure that when you talk in contracts, you talk about issues like gifts and promises. You know, the idea that a contract is a promise. And an oral contract is a series of words that has some legal significance. And then the person who hears the words can rely on those words, and that's why we bind the person. And it's true that if you jokingly say to somebody something, it's not a contract. But if you're secretly insincere, right, then it's reasonable for the person to rely on your statements, and that person would still be able to prove those statements in court. But notice that they're offering the statement to prove the truth of the matter asserted. It facially meets the definition of hearsay, which makes it quite confusing. So, for example, these are the examples. The plaintiff testifies, defendant handed me the ring and said, this is a gift. Right? I'm giving this to you. Offered to prove that the ring was a gift. Hearsay. Defendant jumps up and down. You're offering the statement to prove the truth of the matter asserted. That's hearsay. Well, how else are you going to prove, right? If he just hands you the ring, he might be saying, here, I want you to clean this, right? Or can you hold on to this for me? So you need the words of the defendant. The words are significant. You've got to have them. So even though facially the definition of hearsay is met, this is going to be considered non-hearsay. And it's going to be called a verbal act, and the theory is identical to effect on the listener, right? Because it's significant that the words were uttered. The words led the plaintiff to reasonably believe that he was getting the ring. And now the jury's going to decide, right, whether the plaintiff was reasonable in believing that the defendant. Another example, and this isn't from contracts, this is from, I guess you might do this in torts. Guarantees. Do you talk about guarantees in torts? Guarantee is another thing that you do with your words. Defendant wrote, if you're not happy, return it and we'll refund your money. And it's offered to prove that a return means you get a refund. Truth of the matter asserted. It meets the facial definition of hearsay, but notice that it's the only way you can prove that a guarantee was made. And notice that it has significance even if the defendant is secretly not intending to give you your money back. And you know that happens all the time, right? Guarantees are often insincere. But as long as they're made with the appearance of sincerity, it's reasonable to rely on them. You can prove them in court. And you're not depending on the sincerity of the speaker in obtaining some probative value from the statement. So although they fit the definition facially of hearsay, they're non-hearsay because they have a non-hearsay purpose. And this next example happens several times a year. My wife says, you said I do. And it's offered to prove I did. Okay. Cherish. Obey. Wait, we guys, we don't have to say obey, do we? She says I said I'd obey her, but I don't remember that. I don't remember much of anything from that day, frankly. I was so incredibly tensed out. These families meeting each other, you know, and it's like, well, you just wait till you get married, you'll understand. Okay, so those are all verbal acts. And the idea is, this is the idea, and it's just like effect on the listener. Sincerity isn't assumed because the fact that the declarant made the statement gives it its probative value. Okay? The fact that the declarant made the statement gives it its probative value. And another way that people like to talk about verbal acts is saying it makes it so, right? If saying it makes it so, that's a verbal act. So saying I do in public in front of a large crowd of angry family members marries you, right? Saying this is a gift to the recipient without making it clear that you're just joking around is a gift. Saying I will pay you $6 if you mow the lawn is an enforceable contract, right? And all of those things you have to be able to prove in court. I mean, just be realistic. And so you know, I mean, one of the ways to think about this is if you have to prove it through spoken words, then it's clearly not going to be hearsay, but you've got to figure out the rationale for it. Because some judges are amazing. And let me just tell the story, and then I'll get to your question. So I told you about that one time that I've been on a jury, right? And the judge's definition of hearsay, well, first I'll tell you the judge's inability to understand non-hearsay. The charge was resisting arrest. Now, what would you have to prove in order to prove that someone was resisting arrest? Think about it. Do you think you might have to prove that the cop said to him, stop? So, testimony. And what did the officers say? Objection, hearsay, sustained. Judge wasn't going to allow him to say that the officer said stop. And you got to prove that the officer said stop in order to prove he was resisting arrest. So, judge obviously is a little confounded at this point. And the judge said, well, that is hearsay, but you can tell him the gist of what he said. So the judge's definition of hearsay is you can't quote someone, but you can say the gist. And you'll find, this is like, I talked to this guy about it, this evidence professor about it. He said, yeah, I call that lay hearsay, is that there's this definition of hearsay, and it's not really lay people, it's judges who have these crazy definitions, and that's just one of them. But he was clearly wrong on both points. Yeah, you had a question. No, I wouldn't make it that strong. I wouldn't say it that strong. Because you could prove a gift, you know, it was wrapped up in a box with a bow around it, and they handed it to him. So you could prove a gift without the words. So that was, I'm saying if that's true, if you say you have to prove it, then you know it's not hearsay. But it's much less than that. It's as long as saying the words themselves has some probative force. And then to go back to our conception is that if you say, I don't care if the speaker, the declarant, was secretly insincere, that doesn't matter. It still has probative force, right? Then you say that's what makes it non-hearsay. Okay? Now I want to make sure we get through at least most of the material, because I do want to start with exceptions on Wednesday. So let me move on to verbal objects. And verbal objects are actually quite simple. When you see them, you know when you see them. And it's when you use words as distinctive characteristics of a person, place, or thing. Okay? And this is a little difficult to understand. And when you're using those words independently of what they assert. One way to think about this is that verbal objects would be understood even by a person who doesn't speak the language. Because that's a way to dissociate what words do, what they look like, and what they assert. Okay? So if someone who doesn't even speak the language would recognize the probative value of some words, those are going to be verbal objects. So an example would be the defendant is found with a book of matches. Okay, so the defendant's arrested, and he's got a book of matches in his pocket, and it says AAA Auto Repair. And it's offered to prove that the defendant was at AAA Auto Repair. Oh, and I should mention, I sent out an email late this morning, I'm sorry about it, where I changed these things a little bit from the slides that I sent out yesterday, because I think my changes hopefully will make things a little bit clearer. So here's the example. The defendant has a book of matches. Now, hearsay, right? Well, you could say, well, no, it's offered to prove something different. But remember, as long as what you're offering to prove includes the assertion. And notice that the matchbook saying AAA Auto Repair, what is the writer of the matchbook saying? What are they intending to express these are matches from AAA Auto Repair, right? That's the intended assertion. And they might be lying, right? They might be lying. But notice that we're relying on the assertion in order to prove that D was at AAA Auto Repair. And think of where they were lying. Let's say they hand out AAA Auto Repair matchbooks as a joke at, BBB Auto Repair. Or they got the lettering wrong or something. But notice that sincerity is important. So this would be hearsay. This would be hearsay. And this kind of hearsay is often overlooked by people. Well, the reason it's overlooked is there is a way around the hearsay problem where you don't have to rely on the sincerity of the guy who wrote the matchbook. All you have to do is offer independent evidence that AAA Auto Repair has matchbooks with their name on it. So something will be a verbal object when you can avoid relying on the intentions or the sincerity of the speaker through independent evidence that links the words to what they assert. I know that's hard. I mean, I can say it. I've said it 10 times now, teaching this 10 times. But I know that's hard. So let me show you why this is just like identification where you wouldn't even think of a hearsay problem. That as long as you have this independent linkage, it's called, as long as you have this independent linkage, you don't even think about a hearsay problem. So verbal objects is just a case of identification. So this statement, that AAA Auto Repair matchbooks proves that it came from AAA Auto Repair, remember, that is normally hearsay if you're just relying on the sincerity of the matchbook writer. But that is identical to a simple problem of identification if a further condition is satisfied. So I'll tell you, I'll say, this problem is really just identical to this problem. Imagine that we didn't even look at the matchbook cover. We opened it up and we tested, right? This is the way CSI makes you think about criminal investigation. CSI says, oh, we didn't even look at what it said. We tested the sulfur oxide contained in the match, and there's only one auto repair in the country that uses those kind of matches. And this isn't far-fetched. You ever watch CSI? They really think that this is true, right? This tire was on this particular car on this particular day because we found a piece of gum in the tread that was only manufactured by Wrigley from August 4th to August 6th, 1908, and this guy was chewing that gum. Case solved. All right. Well, how are these the same problem? They're the same problem as long as the linkage between AA Auto Repair is not relying on the assertion. So as long as you prove this, right, that's that independent linkage. As long as you prove that AAA Auto Repair is the only company that manufactures matchbooks that say AAA is the only company that has matchbooks with AAA Auto Repair on it, is the same as what you'd have to do to prove this fact. You'd have to prove that only AAA Auto Repair has matchbooks with that chemical, right? You would have to give independent evidence to prove the true uniqueness of either the statement or the chemical. That's what makes CSI so silly. There's usually no such uniqueness. Usually there are thousands and thousands and thousands of items just like this item somewhere else. Okay? Does that kind of make sense? Should I ask you with the clickers? Do you want to ask a question? So that's what a verbal act is going to look like. I mean, what a verbal object is going to look like. Well, how does this match up with arguments about sincerity? How does this match up? Independent linkage is going to make it irrelevant, unimportant, whether the speaker, the person who wrote the matchbook, was sincere or insincere. So for example, you could use verbal objects to prove identification through independent linkage, even if the speaker was clearly insincere. And what would be an example of that? Well, an example of that would be you go to a hotel room where the criminal has jumped out the window, and you look at the luggage that's left there in the room, and it says Perry Mason. But that could lead you to me, Professor Lyon, as long as there was independent linkage, right? It wouldn't automatically say to you, it says to you, this is Perry Mason's luggage, so it wouldn't lead you to me. But why would it lead you to me if there was independent linkage, right? And what would that independent linkage be? What would the independent linkage be? Evidence that I carry luggage that says Perry Mason, right? And that's just the same as the independent linkage in the matchbook case or the independent linkage in the chemical case. So to reiterate, whenever a statement is offered to prove the identity of a person, place, or thing, and there is independent linkage proving the uniqueness of that relationship, you don't have a hearsay problem. You're not relying on the sincerity of the person who made the statement. Okay? Yeah. Yeah. You have a verbal object whenever you use a statement to prove the identity of a person, place, or thing, and you have independent linkage that establishes the uniqueness of that person, of that person's connection to that statement. So to put it in terms of the matchbook, a matchbook saying AAA Auto Repair offered to prove the matchbook came from AAA Auto Repair is not hearsay if you can prove that only AAA Auto Repair has matchbooks with their name on it. Yeah. Yeah, that's a good idea, actually. Yeah, are those pictures of you? Oh, that's sweet. Yeah. Mm-hmm. Yeah. Yeah, yeah, yeah. And so you could have even written your name Alma on it. And they'd say, look, Alma was here. No, that's an assertion. Well, but only Alma has a cup with Alma on it. Yeah, exactly. See, I'd wonder whether those pictures are even assertive, so you might not even get into that issue. But that's a nice example. Yeah. Mm-hmm. Yeah, that would still work, as long as you prove that. Yeah, you still have to prove the independent linkage. Yeah, yeah. Now, I should tell you, the book cites a number of cases where they don't understand this problem. And the book also mentions the complex interaction between verbal objects and authentication. Because authentication allows for, some things are self-authenticating, and some people say that solves the hearsay problem, some people say it doesn't. So the complications just abound. But the point now is that if you get that idea of independent linkage, and and what's great about this is if, let's say you're not interested in hearsay at all, and I know that's not true. I know you're here taking this class because you want to learn evidence. But let's say you're one of those, I don't know, 5% of students who takes evidence because it's on the bar exam. Then you're in great shape because you know what? The only time they test you on this, they always say, plus evidence that only something, 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 something. They'll give you the independent linkage, and you say that's a verbal object. Okay? So that's a quick and dirty trick for those few students out here who are only interested in getting past the bar. All right. But I know that most of you want to know more. Okay? All right. We only have 10 minutes left. This is the problem with being responsive to questioning, but I think that's a good thing, so we'll be relaxed about it. But I want to talk about the issue of matter asserted versus matter inferred. Because remember, we talked before about implied versus inferred, and there are some tricky cases where the courts say it's non-hearsay because they say we're not offering it to prove the truth of the matter asserted, we're offering it to prove the truth of the matter inferred. And I want you at least to grasp the argument, even though I think it's mostly bogus. Okay, recall that the matter asserted includes what the declarant intended to communicate, or, as we say in common language, what the declarant implied. All right? Now here's where you really got to understand the distinction between implied and inferred. Is this the same as saying that the matter asserted includes what someone hearing the statement infers? Does it always include the inference you draw from the statement? And the answer is no, not necessarily, because the speaker implies, the declarant asserts, and the listener infers. Okay? The listener infers. And oftentimes, in common language, this will often come up, right? Someone will say, that jerk. And you say, are you trying to say that you think he stole this? Right? Are you trying to say? That's implying. And you're not sure because you're inferring that, but you've got to ask the speaker whether they're trying to say it or not. If you gather something that the person is not trying to say, is that hearsay? If you're trying to prove an inference, not necessarily what the person was trying to say. Well, the advisory committee who wrote the rules say this is a potential non-hearsay argument. Okay, this is a potential non-hearsay argument. And this is what they say. They say verbal conduct, which is assertive, but offered as a basis for inferring something other than the matter asserted, is also excluded from the definition of hearsay by the language of subdivision C. All right? And just to reiterate, painfully, again and again, the declarant asserts, and the party offering the statement infers. Okay? Now, notice that I've changed it slightly. Before I said the listener infers, and now I'm saying the party offering the statement. But notice that the inference is something that you will want to draw if you're the attorney offering the evidence. And this is saying that you can get out of the hearsay problem. You can get out of the hearsay problem. And this leads to some very difficult hearsay puzzles that I won't expect you to fully understand because I think we often just don't know what the person is trying to say. I think people are often asserting things that we infer, right? I think the reason why we infer things is because people are trying to tell us. And notice that how much you have to get into the declarant's head to decide what they're trying to say. And that's exactly the problem with hearsay, is the declarant is nowhere to be found. So I think if you're defending against this kind of argument, you say, Your Honor, we don't know what he was trying to say. That's all the more reason for bringing him into court, because we don't know what he was trying to say. But you still want to be able to make these arguments because maybe you are trying to offer the statements into evidence. So these are examples of statements that are offered to prove a matter inferred by the listener and by the party offering the statement, and maybe not intended by the speaker. Okay, so an example of this is the Pacelli case. And the Pacelli case is in your book, and you might want to take a look at this, but I'll describe it. Patsy Parks, brutally murdered, body is burned. Turns out she was getting ready to testify against Vincent Pacelli in a drug case. All right? Typical case of witness intimidation. Pretty intimidating. The government introduced statements of Mr. Pacelli's wife, his uncle, and his friend. So they're all sitting around watching the news, and they say, the body of Patsy Parks has been discovered. It was only partially burned. And they say, boy, what a lousy job. You know, man, you don't, it's like, first of all, you know, if you burn a body, you burn it right. And secondly, you don't leave it out where someone's going to find it. And the government offered their statements, offered to prove that Vincent killed this person. Now, the issue was, the government said, they didn't say Vincent killed this person, but anybody hearing this would say, why are these people talking about what a lousy job was done, right? Unless they were thinking, without implying, without trying to communicate, that Vincent was guilty, right? Well, it's a hard argument, and actually it's not a very convincing argument. The idea is you say, well, what are the dangers of insincerity? What are the dangers that they're secretly believing something other than what you're inferring? What if they're secretly believing that Vincent really wasn't the killer? Since they're not saying it, since they're not directly asserting it, you could say there's less of a problem of sincerity or insincerity. I don't know. I can't even explain it so that it makes sense to me. But hopefully you kind of get the argument. It's whether someone is directly asserting something or not. Another example would be commands or questions, right? Commands or questions would be situations where there's something that you infer from what someone says, but that they're not trying to communicate it to you. And the example of, I think that probably the easiest example, if there is such a thing as the easiest example when it comes to these, is unspoken thought. So two people are arrested, right, in separate places. And when they're first brought together, one guy says to the other guy, I didn't tell them anything about you. And the government wants to offer that co-defendant statement against the other defendant. Is that an out-of-court statement? Clearly, yes. Is it offered to prove the truth of the matter asserted? Government would say no. What we're offering it to prove is what we can infer from that statement. What can we infer from that statement? That there was something to say, that this co-defendant was guilty, right? Wouldn't that make you say, ooh, that sounds serious? But was he trying to communicate this? Was he trying to say, you were guilty? No, he was just assuming. And since he was just assuming, and we're just inferring, he's not directly asserting guilt, and so it's non-assertive, it's non-hearsay. Okay? Now, if you kind of get the logic, that's enough. If you say to yourself, this is baloney, or something worse than baloney, this is ridiculous, because clearly someone could be doing this in an insincere way, right? He could be strategically saying in front of the police, oh, I didn't say anything about you, Jimmy, because he's trying to communicate that Jimmy really is involved, right? I think sincerity is the serious problem here, and I think this should be hearsay, because we don't know what he's really trying to say. But if the judge believes that he has some incredible insight into what people are trying to say and what you're simply inferring, then a judge will buy the argument, and a judge will allow this into evidence as non-hearsay. Okay? So the rule here, yeah. Mm-hmm. So you think that the person who speaks it is trying to say, you're guilty. Okay. Yeah. Yeah, they could be lying. And as long as you think they could be lying about their belief, underlying belief, then you think there's a problem of sincerity, and you think that they're really trying to communicate this. So you would agree with Kristen. Does anyone think maybe he's not trying to communicate the person is guilty? How would you argue he's not trying to communicate that the person is guilty? Yeah. Yeah, he said, I didn't say anything about you, and to the extent that he might believe that there is some connection, that the other guy really did it, you could say that's just common knowledge that both he and that other person share, but he's not trying to communicate that with this message, particularly since the police are right there, He's not trying to tell the police anything. It's just something that he assumes and that we infer. And so it's not something he's asserting. So you see how that's a subtle distinction. And actually, it's ironic that Kristen and Kate are right next to each other, because that's the gap between the two, right? It's hard to draw that line. But as long as you can say, okay, I think he is trying to communicate it, he's trying to deceive, that's a problem, then it's assertive, then it's hearsay. But if you say, no, 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 he's not trying to say anything about guilt, then it's non-assertive, then it's not hearsay, and a judge will allow it. But I agree, I think it's hearsay. I think it's too hard to tell that difference. Yeah, Steve.
With the bank robbery example, with that guy deserves to go to jail. Is that like the very narrowly distinguished difference from what you just outlined?
Yeah, so you could say, is she trying to tell you that he robbed the bank, or is she not trying to tell you? And you could argue, maybe she's not trying to tell you, so maybe you could argue it's non-assertive. And that's a nice example. But I would say, no, no, no. When she says to someone walks up and she says, that guy should go to jail, she's trying to say she wants the person to believe he robbed the bank. So you see how that's an easier case where you could say, no, 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 she really is implying it. It's not something you merely infer. But that's a nice question, because I think you're right. That kind of gets at the same kind of thing that's going on here. It's just a little more on the side of an assertion. Well, here's the rule. The question is whether the declarant intended to communicate more than what was said, right? Which is why your point is a good one, because that's the issue. And if they are, right, if they are trying to communicate, it's clearly hearsay. The problem is it's very hard to decide. And the danger of secret insincerity is serious, right? The danger of secret insincerity is really serious with, I didn't tell him anything about you, right? It's like you could be trying to communicate to the police that the other guy is really at fault. And as long as secret insincerity is a danger, then these are hearsay. And I think, just little old me, think that these are hearsay. But courts will vary. And the reason I teach this is if you're clever, and you get judges who have no idea what hearsay means anyway, and you get judges who want to let stuff in, right? I didn't tell them anything about you. The appeal, of course, is it's a very strong statement for the prosecution, and a pro-prosecution judge will want to let it in. So I think these should be hearsay. You want to at least know how to argue they're not. Okay, we have no more time. So I'm going to save for Wednesday a little bit more talk about the remaining non-hearsay examples, but we do need to get into hearsay exceptions because, boy, there are lots of them. So I'll see you on Wednesday.